Breaking, the Ninth Circuit Court of Appeals has just made history. For the very first time, this powerful court has issued a Second Amendment mandate, striking down California's notorious one-gun-a-month law. This is more than just another case. It's the first time the Ninth Circuit, a court often hostile to gun rights, has been forced to apply the Supreme Court's Bruin standard and declare that a modern gun law simply does not pass constitutional muster. For decades, California has stood at the front of America's gun control movement. With some of the strictest firearm laws in the nation, the Golden State has been home to constant legal battles over permits, bans, and restrictions. One of the most frustrating rules for gun owners was the state's so-called rationing law, which limited citizens to purchasing just one firearm per month. Now, thanks to Nwin versus Bonta, that restriction has been struck down. The Ninth Circuit has made it clear there is no historical tradition that justifies rationing the exercise of a constitutional right. This is the very first a mandate ever issued by the court, and it marks a turning point not only for Californians, but for millions of gun owners across the nation. In this video, we're going to break it all down. We'll explain the case, the ruling, and the mandate. We'll look at how this decision reshapes California's laws and what it means for other states that have tried similar restrictions. We'll dig deep into the legal test used, the Bruin standard of text, history, and tradition, and why this case is the Ninth Circuit finally falling in line. And most importantly, we'll talk about how this affects everyday gun owners like you, and where the fight for Second Amendment rights goes from here. This is Firearms.Explained, and this is a landmark moment you need to understand. Part 1. The case and the Ninth Circuit's mandate. The case at the center of this ruling is Nwin versus Bonta. The plaintiffs included ordinary Californians, joined by organizations like the Second Amendment Foundation, the Firearms Policy Coalition, and the California Rifle and Pistol Association. Together, they challenged the state's law that prohibited anyone from buying more than one firearm in any 30-day period. California argued that the law was necessary to prevent so-called straw purchases and to reduce illegal gun trafficking. They claimed that by limiting law-abiding citizens, they could indirectly make it harder for criminals to acquire firearms in bulk. But the plaintiffs argued, and the court agreed, that this law punished the innocent without actually stopping the guilty. In its ruling, the Ninth Circuit declared that California's one-gun-a-month law was unconstitutional on its face. That means not just in some applications, but across the board. The judges found no historical precedent for rationing firearm purchases. They noted that in the founding era, citizens could purchase, trade, or inherit as many firearms as they wished, with no artificial government limit. But what makes this case truly historic is not only the outcome, but the issuance of a mandate. In legal terms, a mandate is the official order that enforces the appellate court's decision on the lower courts. By issuing this mandate, the Ninth Circuit has gone beyond words. It has taken binding action. This is the first time the court has sent a clear signal that the Second Amendment must be taken seriously, and that lower courts cannot simply ignore the Supreme Court's instructions from Bruin. Gun rights advocates have called this ruling a milestone. For the first time, the Ninth Circuit, often seen as one of the most liberal and restrictive circuits in the nation, has struck down a gun law outright. That fact alone makes this case one for the history books. Part 2. Impact on California and similar states. Let's talk about the immediate impact. In California, the one-gun-a-month rule has been in effect for years, limiting buyers to just 12 purchases a year. This restriction applied regardless of background checks, training, or lawful intent. Whether you were a competitive shooter needing new equipment, a collector seeking rare firearms, or simply a law-abiding citizen making multiple purchases, the answer was the same. Wait 30 days between every transaction. Now, that restriction is gone. Californians can once again exercise their Second Amendment rights without artificial rationing. The court's decision makes clear that the government cannot impose arbitrary limits on how often you can purchase a firearm, so long as you are law-abiding and pass the required checks. But this victory doesn't stop at California's borders. Other states have experimented with similar laws, often citing California as the model. For example, states like Virginia and Maryland have passed or proposed purchase rationing laws. With the Ninth Circuit's decision, those laws are now on shaky ground. Plaintiffs in those states will point to Nwin versus Bonta as proof that such restrictions cannot stand under the Constitution. California officials have already voiced concern. Some have suggested they may look for alternative restrictions, such as enhanced waiting periods or broader definitions of sensitive places. But the truth is clear. The Ninth Circuit has taken away one of their favorite tools. And when the nation's largest, most influential liberal circuit rules against a gun control law, it sends a powerful message to legislatures everywhere. This case also exposes a deeper issue. If the state truly believed the one-gun-a-month law was essential for public safety, why was there no historical precedent for it? Why couldn't California show a long tradition of limiting firearms purchases? The answer is simple: because no such tradition ever existed. For the first time, the Ninth Circuit admitted that modern policy preferences cannot override constitutional text and history. That admission is the real earthquake here. Part 3. The Bruin Test: Text, History, and Tradition. At the heart of this case is the standard set by the Supreme Court in New York State Rifle and Pistol Association versus Bruin. That case established a simple but powerful rule. If the Second Amendment's text covers an activity, then the government must show that any restriction on that activity is consistent with the nation's history and tradition of firearm regulation. In Nwin versus Bonta, the Ninth Circuit was forced to apply this test. California tried to argue that the one-gun-a-month rule was similar to past regulations aimed at controlling dangerous activity. But when pressed, they could point to no historical examples of rationing firearm purchases. The court saw through the argument and concluded that the restriction was an invention of the modern era, not part of America's constitutional tradition. Justice Clarence Thomas's words in Bruin echoed loudly in this case. The Second Amendment is not a second-class right. Just as the First Amendment doesn't allow the government to ration how many books you can buy each month, the Second Amendment doesn't allow the state to ration how many firearms you can purchase. Rights are not subject to arbitrary quotas. For the Ninth Circuit, this was a turning point. For years, the court had upheld restrictive gun laws using interest-balancing tests, allowing states to argue that public safety outweighed individual rights. But Bruin stripped away that power. And in this case, the Ninth Circuit could not avoid the inevitable. The history simply didn't support California's law. This is what makes the ruling not just a win, but a precedent. By applying the Bruin test faithfully, the court has opened the door for countless challenges against other modern restrictions that lack historical roots. From magazine bans to so-called assault weapon bans, every law must now face the same question. Is it consistent with text, history, and tradition? If not, it's unconstitutional. The Ninth Circuit's mandate is proof that Bruin is working, even in the circuits most resistant to change. Part 4. Implications for everyday gun owners. So what does all of this mean for the everyday gun owner? First, it means freedom. For years, Californians had to think strategically about their purchases. A husband and wife who both wanted to buy new pistols couldn't do so in the same month. A collector finding two rare firearms at once had to choose one and hope the other would still be available a month later. A competitive shooter who needed to upgrade multiple firearms for a season of matches was simply out of luck. Now, that artificial barrier is gone. Californians can once again exercise their right to acquire firearms without waiting in arbitrary government lines. But this victory extends beyond California. Across the nation, gun owners are watching. If the Ninth Circuit, the very court that upheld bans and restrictions for decades, is now striking down a purchase limit, it strengthens the position of Second Amendment defenders everywhere. Everyday Americans can point to Nwin versus Bonta as proof that the courts are finally enforcing Bruin. Here's another key implication: lawsuits against magazine bans, so-called assault weapon bans, and ammunition restrictions will now have sharper teeth. Lawyers will argue, if rationing firearms has no historical basis, then how can banning magazines or specific firearm models? Everyday carriers and collectors alike should understand. This decision is a domino. When one falls, it sets the stage for many more. Of course, with freedom comes responsibility. Striking down the one-gun-a-month law doesn't mean chaos. Buyers will still go through background checks, waiting periods, and federal paperwork. But the arbitrary quota is gone. It restores the principle that rights should not be rationed like government benefits. For the average gun owner, the message is clear: your rights are expanding, not shrinking. And that shift can change not just how you buy, but how you think about protecting your freedoms in the years ahead. Part 5. What comes next? Appeals, challenges, and new laws. Whenever gun owners win in court, the natural question is, what comes next? California officials are unlikely to take this loss quietly. Attorney General Rob Bonta and Governor Gavin Newsom have already positioned themselves as fierce defenders of the state's gun control regime. While the Ninth Circuit has issued a mandate, there are still potential maneuvers the state could attempt, including asking for an en-banc rehearing, where a larger panel of judges reviews the case. But here's the catch. Even in bank, the Ninth Circuit would still be bound by the Supreme Court's Bruin decision. The state can delay, but they cannot rewrite history. The Second Amendment Foundation and Firearms Policy Coalition are preparing for exactly this fight. Beyond California, the ripple effect is enormous. States like Maryland, New Jersey, and New York, all with aggressive gun control agendas, are watching closely. If a one-gun-a-month law cannot stand, then other laws that ration or restrict may be next in line for constitutional challenge. Expect to see lawsuits in those states citing Nwin as a precedent. We should also anticipate a political response. Legislators hostile to the Second Amendment may attempt new strategies, such as mandatory liability insurance, increased taxes on firearms and ammunition, or expanded lists of sensitive places where carry is banned. But each new law will face the same test. Does it fit within the nation's text, history, and tradition? The fight is not over. In fact, it may just be beginning. What Nwin versus Bonta proves is that the Bruin standard is real, enforceable, and powerful. But it also shows us that defenders of the Second Amendment must stay alert. Victories in court must be defended in legislatures, and victories in legislatures must be tested in court. This cycle is ongoing, and gun owners cannot afford to sit back. Part 6. Staying informed and responsible. As we wrap up, there's one final takeaway. Information is power. The Ninth Circuit's decision is historic, but it would mean little if gun owners didn't understand it. Too often, rights are eroded not because of court rulings, but because citizens simply don't know what the law allows. That's why channels like this exist, to give you the tools to understand and protect your freedoms. Staying informed means following the progress of cases like Nwin versus Bonta and knowing how they affect your daily life. It means watching for new laws being proposed in your state and recognizing whether they pass the Bruin test. It means educating friends, family, and fellow gun owners so that misinformation doesn't win the day. But staying responsible is just as important. Exercising your rights wisely ensures they remain respected. Purchase responsibly, carry safely, and follow the laws that remain in place. When you do, you show the courts, the media, and the public that the Second Amendment community is not reckless, but principled and disciplined. The Ninth Circuit's first ever Second Amendment mandate is a victory, but it is also a responsibility. It reminds us that rights can be won and rights can be lost, depending on how vigilant we are. So, subscribe to Firearms Explained. Stay on the front line of knowledge. Together, we'll continue to break down every case, every law, and every ruling that shapes your rights. Because the law is only power when you understand it, and when you use that knowledge to defend freedom.